What we're going to be looking at this point in the semester is we're going to be focusing on the fault element of criminal offenses. And we've mentioned earlier in the semester that there needs to be some fault element. It's not enough you just engage in the prohibited conduct. There needs to be some form of fault. But what I want to just introduce today is the concept of fault is actually a fairly elastic one. And that I think a lot of people assume when you're talking about fault, you're talking about somebody who is aware that they are committing the prohibited act. And way back when we talked about the offense of theft, where you need to not only take someone else's property, but you need to have a subjective awareness that that property does not belong to you. That for assault, that you need not only to apply force, but you need to be aware that you're applying force to this person. And I think most people would agree that is certainly a form of fault, because you're aware that you're committing the conduct that the criminal code says you can't commit. But what we're going to look at over the next couple of weeks is fault is not only proven by subjective awareness. There can be other forms of fault. And let me just give you a quick example. If someone decides to set up a fair that children are going to come to and go on to rides, and they set up some kind of merry-go-round, and they think they've done a pretty good job in setting it up, but they've actually used an incredibly dangerous system to do it, and nothing is bolted down properly, and they didn't do any of the safety checks at all that anybody would do who's setting up this type of equipment, and a child is injured on that merry-go-round. Okay, I think we might find in that case that the person did not subjectively know that they were creating a dangerous merry-go-round ride. In fact, their naivete may help protect them from saying, I had no idea. I thought if you just basically set up this thing, it would be fine. Okay, but we might well find that person is at fault. Why? They were reckless. They were negligent. Okay? And the interesting issue is, when we're not talking about civil law, about suing somebody, when we're talking about criminal law, is it appropriate to use forms of fault that are not subjective to convict an accused? And I just want to provide an example of a basic fact pattern and some different levels of fault we could associate. Let's say the victim was walking on a trail in the UBC endowment lands, and the accused was coming up behind them on the trail and wanted to move past them to get ahead of them because the victim was walking more slowly. And that when the accused moved past the victim, there was some contact, and the victim fell down and broke their arm. Okay, and let's say the accused is charged with assault causing bodily harm. Okay. There are a number of different ways we can look at fault within that scenario. And perhaps we can put it on a continuum from the least to the most. One is, we might say that there actually maybe doesn't need to be any fault established, because you've engaged in misconduct of knocking into somebody and causing their arm to be broken. Maybe you should be criminally liable simply because you engaged in the misconduct. Something we call absolute liability. Now, not generally used in the criminal sphere, okay, but we need to think about that. That is one option. We may decide that certain levels of conduct are so dangerous you simply can't engage in them, even if there's no fault at all. I mean, let's say the accused person was moving carefully by the victim and tripped on a route that could not be seen because it was covered with some dirt, and they fell into them. Okay, it was what we might say a pure accident. Okay, you could, if there was no requirement for fault, you would find that person guilty of the offense. Why? They did bump into the person. Okay, they did apply force to them, and that caused their arm to be broken. Okay, one step up from no fault would maybe be a broad form of civil liability. Okay? You might say that fault is engaged if you were somewhat reckless or negligent. Again, you had no intention to bump into them, but maybe you moved beyond them quite quickly. Maybe you didn't check to make sure that you had enough space to move beyond them, and you bumped into them and caused the person to fall down and break their arm. Okay, that is a potential form of fault, including potentially applicable in a criminal law case if we want, that you are at fault for that because you were negligent in how you move by them. Okay, one step up from that, what might be a form of what we might say is gross negligence. Again, you had no subjective awareness that you were going to bump into them, but you were maybe highly negligent in how you did that. You maybe moved by them quite quickly. You chose a place on the path where there was very little room to move through. Okay, and you did it at a high speed, and you didn't mention to them that you were coming up behind them and trying to move beyond them. We might say in those circumstances, again, while you didn't subjectively intend to hit into them, that you were highly negligent, and that could be a fault standard we could use to prove that offense. Okay, the next option would bring us into the subjective. Okay, this idea that you needed to have subjective awareness that you were engaging in the prohibited conduct. But even within the subjective mindset, there are a number of different degrees. We might start with something we call subjective recklessness. Let's say you're behind the person on the path, you're getting quite aggravated that they're going slowly, and you decide to try and jump past them. And you're not sure if you're going to hit them, but you see that there is a risk, and you realize there's a risk you'll bump them, and you proceed anyway. Okay, we're now into the subjective arena, but at a fairly low level, because you don't know if you're going to hit them, but you suspect you might, but you take the chance and proceed anyway. And the person falls and breaks their arm. That's a potential level of fault we could use. Moving up from that is subjective awareness, not just aware of a risk, but you're subjectively substantially certain that you're going to bump into them. You are very frustrated, you're behind them, and you decide to sort of push your way past. Okay, in that scenario, you are subjectively aware that you are committing the prohibited conduct of the assault. Okay, and that would be a more full subjective type of fault standard. But it goes beyond that. There's a couple more options within that subjective, full subjective category. One is, do you have to subjectively foresee all elements of the actus reus? Remember what the crime is here: assault causing bodily harm. Okay, a very high subjective fault standard would say you have to subjectively assault them, and you have to be subjectively aware they are going to break their arm. And there's even a standard beyond that. And that is an idea of maybe you have to not only be subjectively aware that you're doing the basic assaultive activity, that you're aware that you're going to cause their arm to break, but thirdly, maybe you also need to be aware that what you're doing is contrary to the law. And that if you think that it would be permissible to sort of shove someone out of the way as you're going through, and that in those circumstances, as long as you honestly thought it wasn't against the law, perhaps you could have a defense of, I didn't know it was illegal to engage in that act, and now that I know it is, I won't do it again. Okay? And so what you can see there is an incredible range of alternatives with a fault standard that range from no fault standard at all, okay, moving up to a civil form of negligence, and then up to a form of gross negligence, and then into the subjective category. But then there are so many gradations within that, okay, a basic level of recklessness, a sort of fairly substantial awareness of what you're doing, or maybe a requirement that you also know that this is prohibited by statute. And what we're going to do over the next couple of weeks is we're going to look at a number of offenses, and we're going to do two things. One is we're going to try and determine what fault standard Parliament used. That's one of the investigatory techniques that we're going to look at, is factors we can use to determine which one of those many fault standards did they choose. But then the second issue is, particularly if Parliament has selected a fault standard at the lower end, we're going to look at whether constitutionally that can survive. Remember, we looked at the principles of fundamental justice. And again, when you think about putting people in jail potentially for life, having their high stigma of a criminal record affecting them for the rest of their life, we may want to investigate the issue of whether certain fault standards are too low to be acceptable under our charter.